No, my friend, you see? No, my friend, this is what. Baby, you don't want to take a picture quickly.
Greetings, members and all on the platform. The time is now 9 o'clock, which is our time for the meeting. May I just check first with committee support if we've got the required number can start the meeting.
Good morning, Chairperson. Yes, we have the right number to start the meeting, Chair. Thank you.
Thank you. Having confirmed that we've got the right number to start the meeting, let me now formally greet you, honorable members on the platform, Deputy Minister Nemazinga Shabalala, the DG and the officials of the department, commissioners from the fund, the UIF and compensation fund. Let me also acknowledge the civil society. I saw PMG on the platform. We regard you as also important in looking at our work. South Africans that take interest in the work of this committee, utilizing streaming platforms provided by Parliament to ensure that they participate in the work of our committee. I will, honorable members, as I do so, just deal with the formalities so that the meeting is able to proceed properly. That this is a meeting of the Committee of the National Assembly, the Portfolio Committee on Employment and Labour, and therefore bounded by rules of the National Assembly on this platform. In this regard, all members and all other participants on the platform, you are reminded to mute your mics and also mute your video cameras up until at a time when you are recognized by the chairperson. At that point, you'll then proceed to unmute your mic and unmute your video camera. In a situation where you experience connectivity challenges, you would indicate for the permission of the chairperson to switch off your video camera and proceed in that way. We do so for you to maximize your bandwidth. Of course, there may be times when people lose connectivity and you have to come back on the platform. Please ensure at all times as you come back that your video camera is muted and your mic is muted, as microphones are sensitive and could therefore pick up background sounds that may distract the meeting. Honorable members, the rules makes provision for point of orders to be raised. Members are therefore advised that they raise that by raising the hand on the platform using the icons. And therefore, if the chair is unable to see the hand, the committee support will help the chairperson to identify the hand. Only at the time that you are recognized by the chair, you will then unmute your video as well as your mic, proceed to raise the point of order on which the chairperson could rule upon in line with the rules. Honorable members were further advised not to raise unnecessary point of orders to a point where the platform collapses in this regard. These are just the basics to help us to proceed with our meeting. However, all other rules of the National Assembly will apply in terms of how we proceed with our meetings. Honorable members, as it has been confirmed that we do have the numbers to proceed, I'll then now get to a point where we get to confirm if there are apologies that have been received by the committee support. Committee support.
Good morning, Chairperson. The apology that has been received is from the Minister. The Minister is still on leave. And the second one is from the Deputy Minister, Sibiya. He requests to leave early to attend to another engagement, as well as Deputy Minister Nemadzenga Shabalala requests to be excused to attend Cabinet meeting. Thank you, Chair.
Okay, my apologies. I didn't see Honorable Spear on my side, so you are recognized if you are on the platform in that score. So those are the apologies received by the committee. May I just check if there are apologies that may have not been received by the committee that the members would want to place on record? As I do so, I'm also asking Mr. P. Mapa to mute the mic because it now interferes with the meeting. Please mute your mic. ICT must help us to do so if you can't. Honorable members, checking if there are apologies from members that may have not reached the office so that we place them on record.
Honorable Chair.
The Honorable Nonzele, you are recognized.
Thank you, Honorable Chair. Unless I missed out because I was checking if the apology for Honorable Mayeto, unless we did attend, because there was
no, it was not.
Yes, okay. No, thanks.
No, I'm saying it was not.
Oh, okay. No, thanks. Thanks, Honorable Chair. Honorable Chair, I want to submit on behalf of Honorable Mayeto that he has an emergency appointment, medical appointment, so he will not be able to join us. But in the event that he joins us, then it should be accepted that he has completed that appointment. Thank you, Chair.
Thank you. There's an Takwanas iPhone, so I won't know the name.
Thank you, Honorable Chair. I've been trying to rename my gadget just to add the surname that is Nkupane, but now it's refusing today. I don't know why. I would like your office chair to assist me in renaming. Thank you.
Okay, thank you. Indeed, I didn't know it's yourself. I think I ICT would have to help us on that, and the committee support to just identify it properly. So those would have been apologies from members. I now look at the one from, is it CF?
Good morning, Chairperson, Honorable Chairperson. Yes, it is Acting Commissioner CF. Chairperson, I'm in the meeting for now, but I'm going to join the DM for the cabinet meeting because I need to assist with the CF board. However, I do have Dr. Joseph Ledwaba and Advocate Shokane who will take you through the CF presentation if I'm not around. Thank you.
Thank you, Acting Commissioner. Honorable Basson. Yeah, your hand was up and went down and then come back. So
thank you, Chairperson.
Yes.
Chairperson, if I might also request the last half an hour of the meeting, if I can also leave, please. I've got family responsibility, but it will only be the last half an hour.
Okay. Thank you, Honorable Basson. We note that. Honorable members, with those apologies that have been tendered, but as I said, we have confirmation that we have got the numbers to proceed with the meeting. I take it that there are no objections in us accepting those apologies so that we then move to the next item. So the apologies would have been granted in that way. Honorable members, as you'd be aware, because you'd have received a notice convening this meeting, this meeting, more importantly, is also taking place at a time when the country has demonstrated to the world that Africa, in the first place, as a continent, it's an important continent that is able to rise to the occasion. As I said, nationally, more importantly, that the country is well led in this regard. And I think from the point of positioning the continent, the happenings of the G20 this time around have demonstrated that Africa continues to rise and take its rightful place in the world. Gone are the days when would be bullied and would go all the time begging instead of providing the leadership in a way that makes the people of the continent to believe that they are not well represented. And I think in the history books, this is the page that will not disappear, that the country was able to not only have incident-free in the sense of disruptions within the engagements, but it has demonstrated that all the other meetings, including the ones that we've been holding our own department and the ministry to come before the committee and brief us on the G20, all those meetings would have been the build-up to the main event, and they've now been confirmed as such that the country has used the presidency of this G20 to really take the matters that are very important in this regard. Of course, there's a benefit, I think, as the president would have said in answering questions in Parliament, that we treat the visitors well in the country, but we also do other things to demonstrate that we really welcome them. And we hope from a service delivery point of view that indeed we'll be able to keep that standard of services and that work continues in the area, in particular the host city that would have had problems before, and there's a way of turning the corner in a number of aspects in the city. So with that having been said, the notice convening the meeting indicates that honorable members would look at 2 items in the main with the department, and the other item will really be our committee item as you flight it again so that we are able to be focused. In that score, honorable members, is the feedback on the George tragic accident or incident. We will get a presentation on that, which has been already circulated to the members. And I want to guide that once we get to that, after the overview, when we get to the actual presentations, we'll afford only 20 minutes because members would have received the presentation so that the focus is on silent points. Once the 20 minutes mark comes and you would have not finished the presentation, I will indicate indeed that your time has expired. Of course, the next item would be on the feedback on legal costs, as the amounts covered by the department and entities. And in this case, we are focusing on the compensation fund and the unemployment insurance fund as the entities that we refer to, of which honorable members would have received the presentations, including in some cases like the department, a detailed attachment to the presentation. Having looked at the presentations, indeed we'll also try to manage the time as the slides are not in terms of length the same as the first item. We'll then allow the 15 minutes on the presentation itself. And in that score, take a discussion. So how we are then going to approach the discussions so that we know where we are, honorable members. We'll take the George one first, take up a discussion so that we close that item. Then we'll take all the 3 presentations of the 15 minutes each, which is 45. And thereafter then take up a discussion. We'll then move to the next item. When we get to that item, we'll then, the department would be free and the entities to leave if they so wish. But if they decide to stay, they will stay on the platform because that will then be a consideration of a report of the committee on its oversight, which must then be adopted by the committee. I must say this, honorable members. Mr. Muratova, mute your mic. You are interfering with the chairperson chairing the meeting. So in that score, honorable members, I'm raising this so that we are able to have a qualitative engagement that also allows space that there is also a meeting of chairs of committees in the NA, and in the agenda there are also issues that relates to legislation referred to committees, and members would be aware that we have been having a challenge of, for example, the Employment Services Amendment Bill, which has long left cabinet. So it will be an opportunity to also check whether that is in line so that the committee is able to look at this, and if not, at least get a sense of how far that matter is, so that it doesn't look like the committee is not making the movement in this regard. So that meeting is at 1, and hopefully we'll be able to stick to our time of concluding the meeting by 12 in that regard. So I'm trying to explain the part about being strict to the time on the presentations. I know that sometimes the presentation there's an overflow in terms of time, but I would really plead that we really stick to our time, because we have received the presentations, and it's not really very long slides, and you can be able to do that within the time. Having said that, I want to then, in this regard, invite the Honorable, the Deputy Minister, to really speak to all the items that they are to deal with before the committee. Once the Deputy Minister would have concluded, we'll then come to the times, as I said, that are allocated. I hope the Honorable Deputy Minister, you are able to hear me from your side.
Yes, Chair, I can hear you. Am I audible myself?
Yes, you are. Thank you. We can proceed.
Thank you so much, Honorable Chair. Truly appreciate the invitation to come before the Portfolio Committee Chairperson, and also the understanding of the apology that one has tabled, because there is item that of CF that we're presenting to the Cabinet Committee. So, Chair, greetings to yourself, to members of Parliament, and obviously officials from the department led by the Acting DG, Ms. Mulisane, Mr. Ludwaba, Acting Chief Director of Corporate Services, Advocate Shokane, Director of Legal Services, Ms. Morrison, Acting Director, Medical Services, and Ms. Mashinini, Investigations, representatives from two funds, Ms. Matepo Kosa, Ministry Support, of course, Advocate Kondo from UIF that is here. So, Chair, we will not leave you with without responses, but with officials who are quite equipped to deal with these matters. Chair, the committee has really invited the department of with the compensation fund and the UIF to come before yourselves to brief on legal cases. And Chair, it says in the invite that we got that were meant to deal with the legal costs versus amounts required by the department and entities from fraud cases. And you will also see, Chairperson, that we speak about the contingent liability cases, including contingent asset cases, Chairperson. Now, Chair, to support really that we get from the department and holding us accountable, we're really much appreciative of that. So you would also requested an update on the George building collapse that occurred in 2024, and that will go through. Now, before we present this detailed report, Chair, I thought it was quite important to really allow me to join you in your opening remarks, Chairperson, when you spoke about South Africa's being successfully hosting a historic first. Comment South Africa's on that hosting of G20 summit, the first ever on African soil, and the event included several build-up summits that really across multiple provinces and Department of Labor that has contributed significantly to these efforts. Once more, Chairperson, President Ramaphosa has noted, and we have noted in his Monday letter to the G20, and I open quote him. Somebody is unmuted, Sagi. So we would have noted what the president would have said, Chairperson, when the president said in his letter, matters for South Africa not only to cement our important role in the international affairs, but also to support our own growth and creating of jobs. Important agreements benefiting our country were reached, and the summit has contributed meaningfully to positive national outlook, close quote. Honorable members, it is indeed worrisome that we have a pandemic that the president has declared of gender-based violence and femicide against women and children remains one of the most gravest crises facing our nation. It deprives women and children from dignity, safety, and equality, both in society and in the workplace. And as we enter the 16 days of activism against women and children, we enter this with saying joining the no violence against women and children. We must also reaffirm the labor market institutions and employers that play a critical role in addressing GBVF through enforcing workplace protection, rooting out discrimination, ensuring safe working environments. And this department should continue to contribute directly to this ending of this scourge. Discrimination against women persists in many private sector workplaces as well. Many capable, qualified, and experienced women remain in lower levels of positions simply because they are women, and in some cases because of the color of their skin. These practices must be confronted decisively as we continue building a non-racial, non-sexist, united, democratic, and prosperous South Africa. Now, honorable members, Chairperson, please allow me to switch off my video so I can start with the George building. Thank you so much, Chairperson, for your indulgence. Chair, it is worth noting that indeed the George building, the collapse from where we are, Chair, has been quite tragic, and we are really concerned as the department, but with an understanding that the department part is on occupational health and safety, Chair. And I want to say that Deputy Minister Sibiya has been in the forefront as well with the department in ensuring there is much support that is required. And we take it, you would have went through the presentation that the department has shared to yourselves, and also noting the fact that these matters are already at sub judice, and I will explain how, Chairperson, because there are matters within the report itself that the officials might not be in a position to also expand on these matters, primarily because they have been handed over. And want to emphasize the strategic issues really that the George building collapsed on 6 May 2024 at 75 Victoria Street, that there are total number of workers that were affected, and department deployed the OHS inspectors immediately, while the compensation fund also activated its teams. Today, compensation fund, there are claims that they are processing of the workers that are claiming them, and we have the firm as well that received 5 additional claims, and also other claims that they are still verifying. Home Affairs as well has been on the field, we are told, to attend to the issues of affected workers who were all foreign nationals, and Chairperson, we will leave at that, and the people that were there. The investigation required coordination across specialized entities, and all completed all investigative responsibilities and submitted the full report to the NPA. Now the matter rests with the NPA, Chairperson. As we said, we need to appreciate how the Department of Employment and Labor comes in through its Chief Inspectorate around the occupational health and safety. But also, Chairperson, to note that Deputy Minister Sibiya would have went to the portfolio committee of human settlement and portfolio committee of public works to also provide part of this briefing that we're also doing to yourselves, to themselves. And the reason why we're raising this, Chairperson, with an understanding that including the George municipality as well, issues of broader coordination might be important as this matter moves on, perhaps and when the investigations are done, Chairperson, it might be important the portfolio committee has joined with all the parties and other departments that play different roles when it comes to these matters, Chairperson. Now, the police service as well, they are also on the issue. So we will leave, as we said, on our part, we've done our own, and we've handed over all the required requirements that were needed from the Department of IES to the NPA. There are many factors on the investigation that definitely the coordination across these government entities is worth invited. Chairperson, one thing you've noted when you started about legislation, that there are key legislation relevant to the George Building collapse that are administered by the departments, Employment and Labor, and this is just an example, not because all of them, but we are citing this once when it comes to issues of the legislation of immigration and the PS that you're supposed to be having, and that legislation. It's our understanding that as you know that we've been coming to yourself that it should be ceased with the portfolio committee. So we hope the state and on your side of Parliament will be able to bring that forth to yourself, Chairperson, so that you can deal with this detailed legislation, so we can be able to iron out these issues of immigration and migration accordingly, Chairperson. But just to say to yourself, Chairperson, this incidents of this nature, it is quite horrific, including we want to send our condolences to the loved ones of people who really passed on in this tragic building chair. So allow me to just move off from the George Building. As I emphasized, Chairperson, it is matters that are seized with the NPA at this point. So many issues will be matters of sub judice. So we wouldn't be able to, including the officials, to really go into the details of this issue. Now, Chair, you called us today really to speak about matters of the distinction around the legal costs and the recoveries. I want to put it straight, Chairperson, that we would also be appreciative that it is essential to reaffirm the distinction between the responsibilities of the executive and those of the administration. The executive provides strategic leadership and that sets policy direction, and we ensure alignment with the Constitution and our labor legislative framework. Operational matters such as litigation management, disciplinary hearings, labor relations cases, and issues handled by human resources, they fall under the accounting officer and the department administrative system. So you would appreciate, Chairperson, that the team that is here, indeed, these are matters that, as technical as they are, you would have appreciated the presentation that they've provided. That is quite technical, hence they're quite relevant. So as the executive, we do not really interfere with the individual cases. Rather, we strengthen governance architecture, ensure fairness in the processes, and address systematic weaknesses at a strategic level. And the separation of roles upholds the institutional integrity that ensures compliance with the PFMA and the LRA and promotes accountability across department and its entities. Now, there are a few issues from executive level that we wish to highlight regarding the litigation involving the department, the compensation fund, and the UIF. And we want to put it across, Chairperson, that we live in a highly litigious society where disagreements arises, whether in meetings, in workplaces, or also in Parliament. Many quickly go to the courts, and we will see some challenges that happen, including at the level of the Constitutional Court to also claim and defend, and that has been since adopted in 1996, the Constitution that aims to improve the quality of life of all citizens and free the potential of each person. So, Chairperson, in August, we've noted that the court has urgently, application by NIASA and Sakile seemingly to block that issue, the employment equity and all of that. So it's one of those, just to cite an example when it comes to issues of litigation. Now, on this presentation, all of them three, they are citing issues of litigation trends. You would have matters from non-compliance with labor laws and review application that remain the highest categories. The Q4 of the previous financial year recorded 23 non-compliance cases. Q1 recorded 25, Q2 recorded 26 cases, and the review application mirror these numbers. We also deal with the union registration, Chairperson, in the department on or deregistration cases. And we had 16 cases in the last quarter of 24-25 financial year, 18 cases in Q1, 17 cases in Q2. Many unions fail to hold constitutional meetings and must be placed under administration. SEPAO is one of the examples currently in court. Another one is the Young Nurses Union, which has never held a conference despite operating for 7 to 8 years. They are challenged administration up to the Constitutional Court, and the case remain active. This is just to cite to you, Chair, the type of work that we also assist with, officials assist with at the level of the department. Compensation fund on issues they assist with is medical payments benefit. Adjudication remains a challenge. Social media often, makes jokes about people running from millions, referring to RAF payout at times, a similar mentality that influences some compensation fund disputes where claimants expect large amounts of compensation and litigate when expectations are unmet. The fund also faces involving intercepted payments due to the cybercrime, the fraudsters that attempt to divert payments by altering bank details. Fortunately, several attempts were detected early, with some funds recovered through bank reversals and the asset forfeiture unit, and the commission, the people from the commission will elaborate from the legal part. UIF litigation trends, we see manages over 100 cases that it manages annually, including the UIF benefit disputes, COVID-19 tariffs, and you will see them over the 3 financial years that we are counting on the presentation that you had received. The PIA requests, employment-related matters, contractual disputes. Many remain unqualified due to outstanding documentation of legal services that is currently verifying an active versus dormant cases that needs to that they will deal with in terms of closing them and withdraw them from this, so that they are not reported inappropriately. They will take you through, Chairperson, to this contingent liabilities and contingent assets for all of and UIF and the claims that are there and are affected, perhaps workers as well, Chairperson, that they will also speak to. I think another matter worth noting, Chairperson, is that as we stand right now, there are recoveries that have been made when it comes to the UIF, that it has successfully defended the review and set aside of a 5 billion contract, 14 million recovery from Lovedale College with 2.3 million of interest, and that has happened, Chairperson, and that is UIF. On the CF, a total of 27, 664,330 was recovered through bank reversal and AFU intervention. The asset forfeiture unit has obtained preservation orders on 9 cases, Chairperson, with its own value, and they will speak to that, those numbers, because as we said, they are the people responsible. And another Another recovery that the CF has done is around 27 million rands of fraud. We're closely working with the Fusion Center, an asset forfeiture unit, which has resulted in another 20 million under preservation order, Chairperson. Now, these are efforts that are directed to ensure where we need to recover. Indeed, the recovery does happen, Chairperson. Now, collaboration, on another hand, on the issues of the department, the Acting Director General is here. She will give a detailed presentation through her team that she's with. It is important to highlight, Chair, that the department has made significant progress in recovering funds, of course, to the UIF, as I demonstrated, compensation fund, and on fraud and corruption. And that, Chairperson, would come through of a total of 27.6 million that has been recovered through bank reversals and asset forfeiture, as one would have cited, and also the recovery of that 40 million. For us, it is a step in the right direction, Chairperson, is what we want to hear from them. But I want to perhaps indicate with yourselves, Chairperson, in the meeting that the law enforcement, they are also assisting with this type of cases and this type of work that we are really doing, Chairperson. Let me close by saying, trying to quote our president, President Ramaphosa, to say that indeed when he closed on Monday, referring to that letter, and open quote, the success of G20 Leaders Summit together with improving performance of our economy and growing confidence in our reform programs, that shows that South Africa is a country on the rise. And definitely, Chairperson, our future is promising. Let me leave it at that, Chair. If through yourself, I will hand over to yourself, Chairperson, so that you are able to facilitate, of course, the meeting and the discussion. I wish the deliberations well, Chair. Would ask to be excused around about 10 o'clock, if I can, so I can make my way to a 10:30 Cabinet Committee meeting. Thank you so much, Chairperson. We truly appreciate it.
Thank you, Madam Deputy Minister. As we get to the actual presentation, as I said, we'd allocate the time in the way I have indicated. We'll take the first item on George, the 20 minutes. Now the time is 22, so by 10, the time will expire. And we'll take then a discussion immediately after that, so that we dispense with that item before we get to the next item. I think,
Thank you so much, Chairperson. Sorry about that. Acting DG, before you come in, I think I just received just a indication right now from Deputy Minister Sibia that went out from the other responsibility where he's at, because he is directly involved, delegated with IES inspection, especially on the issue of the George case. So he'll be here for that discussion, Chairperson. I thought, let me just put it up to yourself, because we know there was an apology, but he feels this is a very important matter and he would want to also be here. So if you were to just note that, so that when you come to that issue, he is there for it. Thank you so much, Chairperson. Sorry to disturb your meeting. Acting DG.
Thank you very much, Deputy Minister. Good morning, Honorable Chairperson and honorable members on the platform and the colleagues on the platform. I do take note of the time that has been given, and the person who will be leading us on the issue of the George building, it's Inspector General Miliratus, who's on the platform. And without too much waste of time, I will hand over to her to beam and take us through. Without further ado, let me just hand over to Millie.
Thank you. Good morning to the Chairperson, Honourable Members of Parliament, Deputy Minister Sipia, Deputy Minister Chabalala, the DG and fellow colleagues. I'm going to be taking you through the presentation on George and where we are currently. I am going to skip some slides in the interest of time because we've only been allocated 20 minutes and we still have Q&A. So slide number 2 is just a table of contents and what we are going to be presenting to the portfolio committee. I'm going to request that we move to slide number 3, please, Matapelo. So slide number 3, it's just, just want to indicate very briefly, as I've indicated, I'll skip some slides on the mandate of DEL in relation to the incident that occurred. And we want to just give progress on the incident investigation, where we are currently, as well as a brief summary of the compensation claims and where we are with the way forward. If we look at slide number 4, it is just indicating what is our constitutional mandate, and with regards to, in particularly this incident, we're looking at section 24, which is the environmental right, where everyone has the right to an environment that is not harmful to the health and the well-being. That's where we get the occupational health and safety mandate from. And then section 24, where we provide adequate social security nets for the vulnerable workers. In this particular instance, it is the workers that got injured or succumbed due to the incident. If we go to the next slide, it just explains the environmental right. I'm going to skip slide number 5. Slide number 6, it's just to indicate to the chairperson and the honourable members that the long title of the Occupational Health and Safety Act deals with health and safety for persons at work, but also those that are other persons which are affected by where there is a relationship of the employer and the employee. Then, in the purpose of the Act, which is in the next slide, we are going to look at mainly reporting of incidents and the investigation thereof. And if we go to slide number 8, it's just an indication, Chairperson, that the Act does apply to the employees, self-employed persons, and users. So in this particular case, it applied to the owners, as well as the contractor, the subcontractor, etc. So it applies to employers, employees, self-employed, and users. What is very critical, Honourable Chairperson, is that Section 8 of the Occupational Health and Safety Act clearly states that the employer is obligated to provide and maintain a workplace that is safe and without risk to the health of the employees. Also, in the Occupational Health and Safety Act, there is the duties of the employer, and on this particular of employees on this particular section, it is where the employees should not interfere or damage or misuse anything that is provided in the interest of occupational health and safety. What we want to focus on is in the next slide, Chairperson, Honourable Chairperson, is Section 31, because that is the section that enables us to conduct incident investigations. So Section 31 on slide number 10 indicates that the inspector may investigate the circumstances of any incident that has occurred. In this particular case, Chairperson, it is in the George collapse, where the inspectors did do a incident investigation in terms of Section 31. Further, Section 31 also indicates it's in order to determine what is the root cause and what could have resulted in the injury, illness, death of any person. And also, it also assists with making sure that we determine whether there would be a formal inquiry, and that is Section 32, formal inquiry. Section 31.2, which is very critical, indicates what is the next steps that we have to follow as the OHS Inspectorate, where after the completion of the investigation, the inspector submits a written report with all the relevant annexure statements, documents to the Attorney General. In this particular case, it is the NPA, and in the area of jurisdiction, and also a copy to myself, which is the Chief Inspector. This will then enable me as the Chief Inspector to then determine whether we do a Section 32 or a Section 33 inquiry. Then also Section 31.3 is very critical. That indicates that after the report has been referred to the NPA, that we then go into provisions of the Inquest Act as well as the Criminal Procedure Act. Just to note that when it comes to the Occupational Health and Safety Act, that employers can be held criminally liable, and that is why in the introductions we spoke about the fact that the matter is currently with the NPA, and we do not divulge too much information because it is criminal liability. So in slide number 11, it's just to indicate the summary of Section 31, that there is then, after the Section 31 incident investigation is completed, we can then do a direct submission of the report with all the statements to the NPA. There can be a formal inquiry as well as a joint inquiry. In the progress, I'll indicate which one of the three steps we have then decided to follow. So Section 32 is just the formal inquiry, just quoting Section 32, where it speaks about where the Chief Inspector may decide to do a formal inquiry. And then Section 33 is where there is a joint inquiry, Honorable Chairperson, where we as the Department of Employment and Labour then decide to do a joint inquiry, for instance, with the police or with another law enforcement agency. And then in that particular instance, it is where we then have the joint inquiry, where there's a judicial officer that gets appointed to then lead the particular joint inquiry. So those were the two options that's clearly stated in the Occupational Health and Safety Act. Slide number 14 is just an indication, Chairperson, of what it looked like directly. If we look on your right-hand side, what it looked like after the collapse, and then on your left, it is literally what the building looked like after all the rubble was removed. So just a summary of the incident in slide number 15. It occurred on the 6th of May at 2:09, and as indicated in the opening remarks, we then the inspectors were on scene immediately after the incident occurred. There was also the matters related to disaster management, and there was a whole process that was followed. We also had on site the compensation fund and Federated Employers Mutual, which then assisted with processing of claims. So on slide number 16, we just indicate who was involved in it and when were they involved. As indicated, the compensation fund officials with FEM joined from the 7th, even on Thursday the 9th. They also went to the hospitals to go and speak to the injured workers as well as their family. We also involved our public employment services that assisted us with playing a coordinating role with Home Affairs because, as indicated, there was a significant amount of undocumented foreign nationals that got injured. So the functions performed, as indicated, is we then started with the Section 31 investigation. Also, we secured the landfill site at the municipality, stormwater building, where we made sure that some of the rubble was kept for sampling and for any further investigations. And the compensation fund and FEM started with processing social security claims immediately. So the next slide, slide number 18, is just where we are currently, Honourable Chairperson and members of the Portfolio Committee. The incident investigation was underway and ultimately finalized and submitted to myself as the Chief Inspector. And by the 30th of October, we were done with the process, and a decision was then taken by myself after going through the incident investigation report that option number 1, which is direct referral for prosecution, is what I decided on, and therefore requested the inspectors to go and submit the copy of the incident investigation report with all the relevant annexures documents to the NPA, and we decided not to follow the formal inquiry process and also not the joint inquiry process. So ultimately it was submitted to the NPA last week, Tuesday. And if we go to slide number 19, 20, it's just an indication that in terms of Social Security, Section 27, where the compensation fund derives its mandate. Slide 21 is just a summary of the compensation fund claims, just an indication that there were 77 claims that were received, and 68 of those claims were for the compensation fund. And then there was also 5 claims that were received by FEM. There were 4 additional alleged claims, but they didn't receive any documents, just names, and therefore it could not be processed. Then of the 28 claims, of the 68 claims, CF processed 28 fatal claims and 40 injuries on duties, just to indicate that from the information from CF, 15 were South African citizens, 53 were foreign nationals, and there's just a breakdown of the subcontractors. And just the status of the foreign nationals is that none of the 53 foreign nationals had work permits. There was only one that had a work permit, but that work permit expired. And all of this was confirmed with Home Affairs. Then just the status of the claims on slide number 22 is just to indicate that the compensation fund have been processing the claims, but the challenge is that there are still outstanding documents and that the fund cannot finalize processes if there are outstanding documents. And as in slide 22, it's indicated 33 claims have been accepted by the fund, 13 have been rejected due to outstanding documents. And there was one claim that was also rejected because the person did not sustain any physical injury. There were also 2 names that did not match employee records. So that is the status on this particular area. When it comes to the next slide, FEM is just to indicate the claims that they received One of it was for Malawian national, 3 for South Africans, and as indicated in the claims actions, it just states where the particular claims are, but you can see that also there are challenges with submission of documents, and we believe that is because it's also most of the claims are related to undocumented foreign nationals. Slide number 24 and 25. It's just an indication to that the ILO, the International Labour Organization, is currently busy with a project of decent work in construction with 3 countries, which includes us as South Africa, Mozambique, and as well as Zimbabwe. So when this incident happened, we partnered with the ILO, where we've had advocacy sessions. We've also had inspections that were done as part of the project. And on slide number 25, it just indicates what was the compliance levels that during this project with the ILO that we had. And as you can see, when it comes to the compensation for occupational injuries and diseases, only 30% is compliant. 70% of construction employers were non-compliant. If you look at UIF, only 11% compliant. If you look at occupational health and safety, 17%, BCA 52%, national minimum wage, they're doing well with the employers that were visited. Then on slide number 26, it's just to indicate work that the Western Cape has done. Directly after the George building collapse, we did do a national blitz, and this is just the info for the Western Cape, where in the Western Cape they did 311 inspections, and as you can see, the compliance levels for UIF, COID, and occupational health and safety was very low. This was in the month of May of 2024. Then on slide number 27, it's just blitz inspections that were done in this particular year when we also had a national blitz where the Western Cape did 487 inspections. And as you can see, the compliance levels where they were in that particular area also of the Southern Cape, 0% complied with COID, 55 with OSH, and 18% with UIF, and 44% with BCA. So just the last slide on the way forward, as indicated, the investigation was finalized. The investigation report and all the annexures have been submitted to the NPA last week, and the compensation fund is currently processing the claims, and there are areas where they are struggling with finalizing the claims due to outstanding documents. Thank you, Chairperson.
Thank you, Ms. Reuters. I will now, as I said, will take the items in the way I have indicated, that we get 8 members to engage with this presentation so that we conclude on it before we get to the next presentations. The Honorable Nkopane, I saw your hand. I see the hand of Honorable Shezi, the Honorable Mokwele. If I don't see your hand, you'd indicate. But for purpose of time, let's identify and recognize Honorable Nkopane. You can come in. You are muted.
Yes, thank you so much, Honorable Chair. Hey, Comrade Chair and Honorable members, good morning to you, the DMs and all the members on the platform. Honorable Chair, the collapse of this four-story building in George highlights significant concerns regarding workplace safety and regulatory compliance within the construction sector. The investigation conducted by the Department of Employment and Labor reveals that a substantial number of employers engaged in the construction industry in the Western Cape were non-compliant with applicable labor laws and health and safety standards, as evidenced by the 111 inspections with predominantly non-compliant outcomes. Furthermore, the incident underscores the importance of robust enforcement mechanisms, given the tragic loss of life and numerous injuries affecting both local and foreign workers. And it really makes us emotional, Chair, because the recklessness that is there, the employers, this non-compliance is making us really uneasy. So I've just have only 3 questions, Chair. Based on the report and the findings, what specific measures are currently in place to prevent unsafe conditions on construction sites? And how effective have these measures been in reducing incidents like the George building collapse? The second question, Chair, would be, how is the department ensuring compliance among construction employers, especially given the high rate of non-compliance observed during the inspections, and what consequences are enforced for violations? Then my last question, Chair, would be, given that most foreign workers involved in the incident lacked valid work permits, what strategies are in place to identify and curb illegal employment practices within the construction sector? Thank you very much, Honorable Chair.
Thank you, Honorable Nkopane. Honorable Shezi, you are recognized. You can proceed.
Thank you very much, Honorable Chairperson. Greetings to yourself, the DM, the DEL officials, and my fellow members of Parliament. I won't be long, Chairperson, except to say that one is noting the great work that has been done ever since the George collapse. And I just have a question around the issue of illegal, or should I say, undocumented foreign nationals, which I think I'm qualified to say they are illegal workers. What then happens when they are found in that space? Are they compensated, or is the rule of law taking over? Because in my mind, I think they should be arrested along the employer, because they shouldn't be here in the first place. And Chairperson, I also want to say the issue of compliance is really bothering. And in fact, when you have national roads and cars, you try and distribute police officials nationally, and almost every stop point there is an officer who's supposed to stop a car and search if the car is roadworthy and so forth. The DEL inspectors, unfortunately, are not up to task to look into the non-compliances that are happening. And some of those non-compliances, unfortunately, make us lose lives of workers. So what is going to be the remedial action in terms of making sure that buildings and workplaces are inspected? And also to add, Chairperson, what is going to be the strategy of making sure that once a particular building or site of employment has been inspected, there could be a verification method to say that a particular inspector did inspect this building on this date, and if anyone else comes after that date and find that there are things that are not supposed to be there, but the inspector turned a blind eye, how can we punish those? Because in the main, we are worried that most of the inspectors accept bribes and start relationships that are not cordial with employers and compromise the workers and compromise all the legislative mandates that they're supposed to inspect in workplaces. Chairperson, Honorable Chairperson, let me lay it at that. Thank you very much.
Thank you, Honorable Shares. Honorable Mukwili, I had you as the next. You are recognized.
Thank you very much. Thank you very much, Chair, and greetings to you and the colleagues, the department with its entities. My name is Tebogo Mukwili, as you said. I'm deployed by the Economic Freedom Fighters to this committee. Now, Chair, thank you for update in terms of the George incident. You know, it's a very painful thing that the country had to endure. However, we would like to acknowledge the progress that the department has done to this far, and to indicate to the country that indeed doesn't matter how big the company is or how big the employer is. If there was compliance, this incident wouldn't have had.
Hi, how are you? I'm okay. I don't see Pumla's signature on this submit.
We're going to have problems if we are to discuss signatures.
Yes, but I'm.
Mute your mic.
Just hold up, Honorable Mukwili.
Can Pumla also sign?
Let's address the signatures part. ICT, can you remove Pumi? Can you remove? Honorable Mukwili? Apologies for that. I hope you yourself has not lost. Honorable Mukwili, if you can, because I see that you have only the video, the audio side is not connected to the meeting. So I hope ICT has not removed the wrong one. Mukwili, back. In the meantime, Honorable Nontsele, I see your hand is up. I hope you can hear, yes. But it seems
yes, I can hear. I can hear, Chair.
Yes. Okay.
Should I proceed?
I would want you to proceed so that we do not lose more time. We'll check if Honorable Mugul is able to come back to the meeting. Are you back now?
I'm back now. Please.
Okay, no, Honorable Nonzele, I beg your indulgence on this, that we allow it to just conclude. I'll get back to you, Honorable Nonzele.
That's fine, Chair.
Sorry about that.
Thank you.
Honorable Mugul can proceed.
Thank you, Chair. We are in the bundus, so we can't allow to be disrupted. Like I said, Chair, to say this is an indication that we lack capacity in terms of making sure that the companies comply. If the companies complied, this incident or this disaster wouldn't have happened. It doesn't matter who goes to get the fatal results in terms of death, because most of our African brothers are the ones that were affected more. And they were affected because one big company decided to indulge in an illegal activity of appointing people that are not documented and that are not South Africans. That is why we find ourselves, is because of companies wanting to have cheap labor. So as a result, we are in this mess. However, as the EFF, we acknowledge that the department at the end took the matter to the NPA. We are going to make sure as the EFF that we monitor the process and we monitor the progress of this case, and we make sure that those that are being found to be guilty face the arm of the law. Chair, I've seen that there is a lack of compliance in the Western Cape, preferably. The Western Cape is not compliant in terms of the OHS, in terms of so many legal compliant mechanism that is supposed to. So my question to UI is that to the department is that how are you going, despite the fact that you have done bleeds, how many companies that you find being non-compliant, make sure that they are compliant and they are facing the arm of the law? And in terms of the main contractor of that George incident, how far are you in terms of making sure that a criminal a case is open against an individual, and issue of those undocumented workers that were working there? How do you link with their families and make sure that those that are compliant in terms of getting subsistence or benefits, what is it that the department is doing to make sure that their families are being compensated duly so? Thank you very much, Chair.
Thank you, Honorable Mkule. Honorable Nonzele, your last on the discussion. Once more, apologies for that thing that happened. Can proceed.
No, thank you, Honorable Chair. Good morning to you. Good morning to honorable members, our deputy ministers, and the leadership of the department, as led by the acting DG and the fellow South Africans. Honorable Chair, I'm in full agreement with the observations that have been made by my colleagues with regard to the situation relating to the disaster that happened in George, and the extent to which the attitude of the employers has been displayed, including the failures to ensure that they comply with the minimum requirements that guarantees safety at the workplace. I think it would be important also, Chair, to re-emphasize the point that the reality of the matter is that employers are always up for profit maximization, and some do not even have a buy-in on our transformative agenda, that is South Africa. If we look and refer to our seminal document, the Freedom Charter does in fact make commitment to employment, including the safe conditions at work, including the extent to which these are in fact extended to all areas of work. But however, what you find in particular to our 9th province, which is Western Cape, you would find that too often they work at variance with the national requirements, that is in terms of the law and in terms of the broad principles that are accepted as in fact defined in various chapters of our documents. The other important point, Chair, that I want to, in agreement with the colleagues earlier on, is to also to argue for to steps that must be taken in order to mitigate future incidents, that we should in fact ensure that the regulatory authorities should intensify regular inspection and compliance monitoring, especially targeting high-risk construction sites. And therefore, the implementation of a mandatory safety compliance certification system could ensure that only qualified and compliant contractors undertake construction projects. The last point, Chair, that I want to emphasize is that the George building collapse incidents underscores the necessity for a multifaceted approach, combining stricter enforcement and proactive land inspections, as indicated earlier on. That would ensure that we guarantee improved worker conditions and also integrated efforts to combat illegal employment. Because the issue, Chair, of the employment of illegal foreigners, particularly in that province, that is the Western Cape, is a matter that needs to be attended to quite urgently if incidents like this one are to be avoided into the future. My questions, therefore, Chair, are as follows. I've got just 3 questions, Chair. What protocols are established to conduct through thorough investigations into construction disasters? And how are findings used to implement systemic changes to improve safety standards? The second one, how does the department support vulnerable workers, including informal and subcontracted workers, in accessing social security benefits and ensuring their fundamental rights are protected? As you would note, Chair, particularly what is raised by my question in this instance is with regard to the extent to which those workers who were illegal foreigners, their rights have been fully protected, particularly in ensuring that their benefits are fully extended. Where, for instance, the department has in fact been forced to extend such, what steps then are supposed to be taken to ensure that the owners of the building fully compensate the department? So the concluding question, Chair, would be as follows, that in what ways can interagency collaboration, particularly between labor, immigration, and safety authorities, be strengthened to prevent illegal employment and enhance safety regulation enforcement on construction sites? Thank you, Chair.
Thank you, Honorable Nansele. You were asked to contribute on this item. I take it that the Deputy Minister who is overseeing this part from the side of the ministry would also be in, as indicated by Honorable Nematsenga Shabalala, that he may stay with us, hear these points, and be able to make the necessary contribution as we would have received the DM's apology. So I'm just making this point so that if there are matters that you would want to tighten up at whether in the beginning or the end, we'll still give you that opportunity given what Deputy Minister Namadzinga would have raised. And we really do appreciate that you had prioritized this aspect so that whatever comes out, you are able to also follow through from that responsibility given. So I just thought I should place this also on record. But of course, we'll be guided by yourselves now, Deputy Ministers, on how you are approaching the answers and your team. Over to you.
Thank you so much, Chairperson. Like we said, Chair, DMCBR is here to deal with this matter, but maybe for myself, as part of parting short on the issues is primarily raised, I think Menkupane and the whip, I think that will be covered. That the CBR will indicate how all these issues that have been raised are going to be covered. I think just for myself, really, just to say this is a very unfortunate incident that really transpired, and it's not incidences that we want to see. I'm sure the Prime Minister will speak to issues of capacity and the number of work this IES is involved with. I think the point for me, really, when it comes to what Honorable Shezi would have said, when it comes to, I think, issues of construction regulations and permits notifications, there are duties really designers and contractors should be able to provide. Housing Consumers Protection Act, it's also elaborate around that, so that what Honorable Nenzele speaks about when he says that there must be a concerted effort of accountability from relevant stakeholders that are involved, including the George municipality itself, Comrade Chair. But let me leave it at that. Thank you so much, Chair. Please, can I hand it over to DMCB? May I be excused, Chair? Thank you. DMCB?
Thank you very much, Honorable Chair. Thank you, Deputy Minister Namadzinga Chabalala. Thank you for what you have done. Chair, through you, I will continue where the Deputy Minister has left. I want to greet yourself, Chair, the honorable members of the Portfolio Committee, and the team led by the acting DG from the department, and everyone who's part of the meeting, the South Africans in general. Chair, I want to start by responding to the first question that was asked by the first member. Chair, the reality that I want to deal with is one where we must make it clear that the investigation that we went through to deal with this matter was not an easy investigation, but also it's an investigation that is highly regulated within the occupational health and safety regulations, which also guide us on what we need to do and how it has to be done up until its conclusion. And when we conclude this investigation again, there are clear determination and processes that we should follow in terms of how we must handle the investigation up until it reaches its finality, which is finality, as the DM has said earlier on, is the NPA, and we have handed over the investigation to the National Prosecuting Authority. The Chief Inspector becomes the main person in dealing with the investigation. and taking the decision on what needs to be done. And on this one, as she has said, and the DM has said, the matter has been taken for prosecution. This investigation has not even been discussed with the executive in the department because of how it is being handled. If it can be presented to us as the ministry, that will be interference, and that will be like it is being influenced. So it went straight to the NPA without even being presented to us, which we appreciate because it's a proper, thorough investigation, and we're fully having confidence on it that it's an investigation and the report that we will really make sure that people do take the responsibility and there will be consequences to what happened in the George collapse. So I want to assure the portfolio committee chair that the investigation that was done and its conclusion and the report that we have sent to NPA, it's a solid, and we have covered everything. We've made sure that we deal with all the matters. We want this really, Chair, as the members, as I'm listening, Chair, all the members are really concerned with what is going to happen, what happens. Are we sure that people will take responsibility, those who are supposed to take the responsibility? We went down to the deep end to make sure that unturned, Chair. Chair, the issue of the measures that can be taken to reduce such incidents. One, whenever in South Africa there is a construction that is taking place, the building owner and the construction company involved, they have a responsibility also to inform us, to inform the Department of Employment and Labor. Remember, we are not everywhere. It's also their responsibility to tell us that, so that we are building here, they need a work permit, they need everything. So it's not like we are everywhere all the time, but they have a responsibility. It's like in business, when a business, a company owner doesn't comply, at times we are unable to know that this company is not complying because we are not in every company every day. Due to the resources that we have. But it is the responsibility of those who are the construction companies to make sure that they come to us and they report on the work that they are doing, and then we monitor, we issue the permits that we need to issue based on what has been given to us and reported to us. I'm saying this because there is an element of dishonesty amongst some of these construction companies. And they give us an information that they are going to construct a particular building in a particular way, only to find that along the way, they change altogether the scope that they gave us. So these incidents can be stopped, Chair, and be reduced by us as we do now, and we've been doing, enhancing our enforcement and our inspection and enforcement work every day. But we can't be only in construction sector. We are everywhere. We are dealing with all sectors. I want to emphasize the issue of resources, Chair, because I would want to pursue that this committee assist the IES branch to get more inspectors. Chair, if we can double the number of permanent inspectors, because the reality is that for an inspector to have an authority to do his or her work, must be trained, must be permanent, must be an inspector that has been capacitated, meeting all the levels that are there for inspectors to do their work. So you need a fully fledged inspector to do this work with authority, because OHS and even other, whether it's BCA or COID, they all need qualified, trained inspectors. So I'm pursuing and persuading this portfolio committee to assist us on that. What happened if the illegal immigrants are found? Do we Chair, you said it. I think Honorable Nonsele raised it. This country protects everyone who's in this country. Being illegal doesn't mean that you are not a human being. You remain a human being that is in South Africa, and we have a responsibility as the state to make sure that we protect your rights as a human being. So the rights of human beings who are South Africans remains the rights of human beings who are non-South Africans. Even if they are illegal, they deserve to be protected. Yes, when they are found, we deal with them through Home Affairs. The immigration officials who work with us, they are dealt with, they are processed, they are deported. If they are illegal in the country, they remain illegal, but they have rights. So we have processed, Chair, as the Chief Inspector has said, we have processed some of those who have provided us with their papers. It doesn't matter whether they are illegal, but they still need to be compensated because they provided labor to the company. They sold their labor to the company, and they must be compensated for selling their labor to the company. So I'm just trying to narrow it down to that. That's what our law says, and we are working within the law. There was an issue, Chair, regarding our inspectors taking bribes. Chair, I must say, and I think, Chair, you know my stance on this. Yesterday, I was addressing the inspectors coming from all over the country in Durban. And Chair, our inspectors are ethical. It's easy to point fingers and make allegations that our inspectors are taking bribes. They are not ethical. We have asked anyone to give us evidence that Inspector so-and-so has taken a bribe from this company. Chair, I can assure you, those inspectors will be removed from the department. But up until today, no one has ever brought forward the evidence. And I will stand on the side of the inspectors that I'm leading and delegated to lead, to say they are ethical, they do their work. Those that will find that they are not doing their work, easily, Chair, will remove them out of the inspection and enforcement branch because they won't deserve to be part of labor law enforcers. So that one I'm very clear, Chair. And I will say, if Honorable Shezi has an evidence, he's welcome to bring it forward. Everybody becomes easy to blame law enforcers and say they are corrupt, they take bribes and all that. It's easy to say that, but give us evidence and we'll deal with that. Chair, I agree that with the Honorable Mukwelu that the issue of illegal immigrants in the country, it is because employers want cheap labor. It's about exploitation. It's all about exploitation. It's easy because they don't respect the labor rights. They don't pay them what they deserve. They abuse them. Even the working hours, the working conditions that they are working under and subjected to. It's all what employers are doing. And we are working very hard as the department to deal with this. And it has to be stopped. Thank you. We note that the Honorable Mukwelu says they appreciate the work that has been done and they will be monitoring the process within the NPA. We are also looking forward to see what the court is going to say, because for us to be able to say to the committee, this is what we are going to do on this matter, this is what it will be determined by the NPA, because the court is going to test our report, is going to test our investigation and its credibility and the work that we have done and the things that we have identified. And that's the only time when we can say, yes, the court has said this, and it means these are the things. We might have ideas now and things that we can say, this is what needs to be done, this is what, but up until the court pronounces on our investigation regarding the George matter, we are going to wait for the court, and then we'll be able to have proper interventions. But yes, in general, we have upped our inspections in the Western Cape, but also we are monitoring quite a number of construction sites in the country and working with some in the sector of construction to try and curb and stop this non-compliance and undermining of our labor laws. I'm trying to answer quite a number of questions, Chair, at the same time. What are we doing to make sure? I think I've answered that, Chair, already in trying to combine all the questions. As I'm going to be landing, Chair, I'm trying to look at Honorable Nonsel's questions. I I can assure the committee that yes, we are now working hard. I agree with Honorable Nonsele in terms of multidisciplinary enforcement agencies to work together. We are working very closely with Home Affairs. We are working very closely with SAPS. And now, Chair, we have taken a stance where we have brought in even NPA to work with us in our inspection and enforcement work. We have met with them in KZN. We're meeting with them in different areas to make sure that we close the space, because at times, even when these cases are taken to court or we leave them with SAPS, there are some gaps. We're closing all those gaps. We're trying to enhance our work, Chair, and we take the counseling from the members of parliament and the issues that they raise. They open our eyes and we try to make sure that we address those areas. We do support the vulnerable workers, Chair, as the Chief Inspector has said, in trying to make sure that they access the social security that we have in the department through our inspection and enforcement, in making sure that companies do comply with the, whether you talk about COID, whether you talk about UIF, it's part of the work that we are doing to protect the vulnerable workers in any case of injury, in any case of losing their jobs. So we are working very hard and try to make sure that they do get their benefits. We are working with UIF and Compensation Fund, trying to make sure that they respond urgently as well when it comes to the claims that are sent to them. Other than that, Chair, I can assure the committee that this is a matter that we are looking at it very closely, and we want to see it through its finality and make sure that those who are responsible do take the responsibility. That's why on the issue of criminality, it's now on the NPA, because once it's on the NPA, there will be criminal cases and people will take responsibility. Thank you very much, Chair. Maybe Millie can add if there is anything to add. Thank you, Chair.
Ms. Raiders, if there's anything to add.
Thank you, Chairperson. I think our Deputy Minister has covered everything, maybe just on the side of the Western Cape. I would like to indicate that there's a lot of work that the Western Cape has done. As you could see, the compliance levels in the Western Cape in the construction sector is exceptionally low, but they are also doing advocacy work. And then also, what the Western Cape has indicated that they've also done advocacy sessions even within George when it comes to compensation for occupational injuries and diseases, to try and assist people to comply and to make sure that people know what are the benefits that are due to them. Thank you, Chairperson.
There's a hand from Honorable Nonsele. But here on what point, Honorable Nonsele?
Thank you, Honorable Chair. No, Chair, it's just a point of clarity, so that for purpose of record, I'm not quoted as almost same with other groups. On the question of the employment of foreigners, illegal foreigners, the point I was saying was that the department, as an operating or responsible department for employment, there are instances where employers would not register workers, and then those workers, when they submit claims in the department, it would be established either they have not registered as employers within the compensation fund and so on. That then complicates the cases of workers. But in the positive way that the department is approaching, where in fact it claims the money back from the employers, but ensure that the workers are covered. So the point I was making was that because these workers are illegal foreigners and may not have been exposed to these benefits, where the employers have in fact failed to pay, that principle of ensuring that employers do in fact compensate the department, or the department fines them, for lack of a better word, that principle should be maintained. Not to say illegal foreigners should be excluded. No, that was not the intention. If I was not clear, so that the clarity that is made by Honorable Deputy Minister is understood and is accepted in the manner that I'm saying, not that we're at variance with one another. Perhaps I'm sure my question was maybe it was not clear or not properly captured. That's the point I wanted to clarify, Chair. Thank you.
No, thank you, Honorable Nonzele. Not sure if Deputy Minister would want to come back on this issue. It's just that as I listened to it and taking my notes, as he was getting to that response on your questions, he was indicating that whilst he answers one question on the other, it links to an answer on the other. And if I were to be specific, Honorable Shezi would have asked this question about the illegal, and he said, of course, they're undocumented, but they are illegal. What happens to what they get paid, or you just arrest them with the owner and leave? So, but the Deputy Minister can speak for himself if there was that understanding from what you are now raising in that score. Honorable Shezi.
No, thank you very much, Chairperson. One must appreciate the response from the DM. Honorable Chairperson, I don't want to be understood as someone who insults inspectors. I don't want to be understood as someone who does not appreciate the good work, the little good work that the department is doing. I'll say the little because even the department itself does admit that they cannot be everywhere, and therefore there's the scope. I'm sorry about that, Chairperson. So the scope is somewhat limited. But I do want to say, Honorable Chairperson, when you go to a workplace and the worker starts lamenting his problems, and then you say, don't worry, I will call Department of Labor. And then the employer tells you, no, those guys come here frequently. But there is nothing that changes. I was in one instance, I was really taken aback when a garage employee told me that they complained to an inspector that they are getting paid on the hand, and therefore and they need help, and the inspector asked them, what's the problem if they're getting paid on the hand? And such things, I may not have seen any brown envelope, but when the inspector is going to go to a workplace and leave the workplace like it was before, then you have no other reason but to suspect some allegations, to make some allegations of a irregular relationship between the inspector and the employer, which may also be funded. But thank you very much, Chairperson. I just wanted to clear that one. Thank you. And sorry, before... sorry.
Yeah, if you, when you have to speak, I see another follow-up that coming from Honorable Mugwele. Honorable Shezi, if you can conclude your point you wanted to make.
Okay, thank you, Chair. I don't know if we could have a mechanism that would tell us that when an Inspector X has been to a particular workplace, at least for 6 months, we know that he has dealt with 1, 2, 3, and we can go there and verify. Thank you very much, Chairperson.
Thank you. Honorable Mugwele, on that point?
No, thanks, Chair, and thank you, DM, for the response and acknowledging that we've got undocumented foreign workers that are not, we don't know whether they are illegal or legal. Once they get to the company, their status, whether they are illegal, is subject to Home Affairs to confirm. So we are safely calling them an undocumented foreign workers. No, man, Chair, I think I don't know if my issue was responded to. I couldn't hear both from the Chief Inspector and the DM in terms of the compensation for those that have passed on, and then their families happens to be from other countries. What is it that the department is going to do? And also this thing of employers not registering and not contributing. We know that the department will then pay the workers, they will pay the workers and then claim from the employers. The success rate of that exercise, are we getting value for money when we do that or not? Because once we don't get value for money, it's as good as we are not punishing, or we are not holding the employers that are not compliant to account. So I just want to check into as to value for money. Do we get value for money for that exercise? If not, what is it that the department is doing to make sure that these companies are compliant? Thank you very much, Chair.
Dear, Honorable Speaker, can come in and direct how then you clear the floor.
Thank you, Chairperson, and thanks to the members for all the follow-ups. Let me start by the one from Honorable Nonsele. I think Honorable Nonsele was clarifying himself, and we are together. And Chair, your response to it is exactly how you said it. I don't want to spoil it. It's exactly how you responded. And we are together with Honorable Nonsele. So I don't want to dwell much. It was well covered by both Honorable Nonsele and yourself, Chair. That one, we are together. I was trying to answer some questions and overlap to other questions. Thank you. And Honorable Shezi, thank you, Honorable Shezi. I think I will agree with you, Honorable Shezi. What you are saying, we get it almost quite a lot. Where workers themselves, they tell us that we are not happy because the department has been here, but we haven't seen much of the change and all those things. And it's natural, it's humane, it comes natural. Where if there is no change, the conclusion is simple. It means you are a collaborator. If I come to a company and then there is no change, the first thing that comes to mind of a worker whom is vulnerable, is aggrieved, is being ill-treated, subjected to worse working conditions and harmful working conditions. The first thing is that it means the Department of Labor, I'm going to say the Department of Employment and Labor deliberately, is collaborating with them. With the employers. I fully understand it in a manner you are saying it, Honorable Shezi. And it's a matter that we deal with every day. We're trying to make sure that the inspection work is credible. But also what happens is that at times we issue notices and contravention. We give companies time to deal and correct what is wrong. Let me make an example. You find that a company is not complying with a particular labor law. The law says we must issue them with a notice. It depends how grave is the offense, and we will give them maybe a month or 2 months or 3 months to say rectify this. Within 3 months it must be rectified. Within 2 months it must be rectified. So in that 3 months, workers might find themselves, saying nothing is happening. But yes, there are companies as well who undermine our contraventions. Even if you give them 3 months, 3 months will pass. And then the inspector will have to go back and deal with that matter. But some as well, they frustrate even us as the department. They take us to court, even if we've done we've issued some notices and contraventions to say maybe the company must pay workers, it owes workers, must change this and that. It will take us to court and delay the process for more than 2 to 3 years. At times, even if the court awards workers a particular award, they go to appeals. They appeal and do all those things. So there's quite a number of employers, Chair, and the members. They try by all means to evade and not to comply using other instruments that are the legal system that we have. It's just criminal and wrong, and it's not supposed to happen, but it's what is there based on our constitutional democracy, which allows people to use instruments that are there. But I understand, Honorable Shiz, what you are saying very well, and I've heard that, I've seen that, and it comes natural to workers. And lastly, Chair, Honorable Mukwel, it's the issue of compensating. Let me use the undocumented foreign immigrants. We as I said earlier on, and Millie will come into this because the question also assists me to probe further some of the things within the team. We do compensate those families and those workers who get injured, even if they are undocumented, but as long as we get their documents that are needed by the department. What the chief inspector was saying to those that we couldn't process, because no documents were submitted, and then it becomes a problem because that will be a query even to us to just pay where there are no documents and there is no paperwork that has been submitted to the department. I would love the issue of the difficult one, the issue of value for money when it comes to where the department will pay, and then we have to claim from the owners of the business. I will ask that the chief inspector comes in and deal with that. Thank you very much, Chair.
Thank you, Chairperson. Can I come in?
Please continue.
So, thank you, Chairperson. So just to give an update, the Compensation Fund did submit a report through to the Office of the DG for a cabinet memo that we're busy working on. What's a little bit more detail. So the temporary total disablement that was paid for 9 people amounted to just over 106,000. Also, there were permanent disablement claims that people were awarded 100% percentage disability, and that is where people will get pension on a monthly basis. Also, the compensation fund has paid burial expenses as well as a widow's lump sum. The burial expenses that they paid for is 17,139, and also the widow's lump sum was just over 20,797. All in all, the compensation fund has paid a total of 6.1 million rand to the subcontractors that are with the compensation fund for their medical expenses. So that is just to respond to the question of where we are. So there's payments that have been made by the compensation fund in the areas where they are not able to have sufficient documentation. They cannot process the claims and ultimately make payments. The compensation fund did indicate that 26 claims were eligible for benefit payments, but they are unable to do so because there are insufficient documents. And as indicated, the Western Cape, the Compensation Fund, as well as Federated Employers Mutual have literally bent over backwards to try and get this particular documentation, to try and assist so that benefits can be paid. But unfortunately, if no documentation is submitted, they can't. So with regard to the matter that TM requested me to speak to, normally what happens is that if a worker gets injured, contracts an occupational disease, etc., the fund will process the claim, but money claimed back is literally where the inspectorate would go to the employer, go and do a payroll audit on the employer to make sure that any outstanding levies dating back to maybe 3-5 years of not submitting their return of earnings, that they then pay that money. It's not literally if, like, for instance, the 6 million rand in medical benefits were paid, that it goes and that the fund goes and claims the 6 million back. It is making sure that where they were non-compliant, the inspectors does payroll audits. And normally what we do as the inspectorate is we would then do the calculations, and the employer needs to then pay the outstanding levies that were due to the compensation fund and even the UIF. Also, when it comes to non-compliance, what we do is we refer all our cases to our statutory services unit within the inspection and enforcement services. Ultimately, matters get referred for prosecution. And I think an area, Chairperson, where we're having challenges with is when it comes to the Department of Justice and cases being referred to the Department of Justice for prosecution, where we would find that there's no follow through to make sure that people do get prosecuted. It's an area where we, as the Inspection and Enforcement Services branch, under the leadership of Deputy Minister Sipia and Ms. Egi Moilwa, the Inspector General, that we're working closely and trying to get the NPA to assist us with making sure that when we're done with our work as the inspectorate, that there are ultimately consequences for those employers, contractors, etc., that are non-compliant. Thank you, Chairperson.
Thank you. Honorable members, I think we have tried to allow space for engagement, clarify and reclarified. I think from the signs I was looking at on the chat, there's been some levels of satisfaction in those clarities that got to be made, but also how members would have been understood or misunderstood. With that, let's then at least conclude on this item, Honorable Deputy Minister and your team, that you would have heard it for yourselves, that the committee appreciates that as it scheduled this item, that finally we get a report. And you'll be aware that there were members consistently who would have raised this matter, that the other departments may be giving reports, but we are unable to get a report on our side, which in the main was also dependent on others also coming on board because it was a joint approach. So we really appreciate that it is now cleared, at least on our part. We can now follow up the outstanding matters, in particular the part of the NPA. Surely out of it, from the inputs made by members, there's clarity that the measures that are in place, we may need to continue to improve in the main from a point of preventative than reacting to a disaster in that score. And I think that message comes out very clear. I think on the collaboration aspect, it may be that that's something you may want to also consider, that over and above sister departments that you work with, like Home Affairs, the subs as well as the justice side as it relates to NPA, that the sector itself, it's something to consider on whether you can't have some working arrangements formalized, because whilst we may not have resources to have inspectors everywhere, such agreements may go a long way in adding the resources available, because it is also in their interest that the environment that they operate in complies, like it is happening with the other sectors where they are organized in a way. So surely the construction side also participates in some organized business platforms or organizations, and maybe something to look at, so that with the numbers we have, including those that would add through Project 20,000, we can then deploy the resources where they are needed most, and where there's a way of being complemented by those that are in the sector, of course, on agreed criteria and so on. It's something to look at. So with that, Deputy Minister and the team, at least that item now is concluded. We did deal with the apology before, but of course we'll then be proceeding to the other three presentations. In that score. Deputy Minister, I saw your mic was opening up.
No, Chair, I wanted to thank you and the members. We really appreciate the opportunity to come and present to you. And definitely, we will also continue briefing the committee. It's the priority committee for us. And we were not happy in ourselves to go and brief other committees before briefing our very own. Make sure that moving forward, we brief the committee first. And thank you so much, Chair.
Thank you, Tim. We now move to the three presentations, now 11:03. As I said, we'll really look at 15 minutes per presentation. We'll take all the presentations at once and then take up a discussion. And I'm sure at this point, it is the Department of Employment and Labor, will then be followed by the UIF, then the Compensation Fund, in that order. Yes, ATG?
No, thank you very much, Chairperson. I will hand over to Mr. Given Mditwa, who will present on the litigation issues of the department. I'll hand over to him and also just indicate to him that he must be mindful of the time. Thank you very much, Chairperson. I'll hand over to him. Thank you.
Good morning, Chairperson, honorable members, honorable Chairperson, honorable DM, DG, commissioners and colleagues, all protocol observed. My presentation will cover litigation cases for the department over the past 3 financial years, including ancillary matters. Just before I start, I wish to indicate that our presentation should be read together with the detailed narrative litigation report that has been submitted. I also wish to indicate that our work has been done in compliance with applicable legislation and relevant policies, including our standard operating procedures. In terms of table of contents, I will cover issues around contingent liabilities and contingent assets, the number of litigation cases and the total thereof, legal costs or fees paid to date, types of matters and trends, and conclusion. My apology for that. In terms of our contingent assets, I wish to indicate that during the financial year 2023 to 24, we had a contingent liability amount of about 28 million, and our contingent assets were at 571,000. In the financial year 2024-25, our contingent liability amount was at over 26 million. Our contingent asset was 0. Members will ask why we have a contingent asset at 0. It so happened that at the end of the financial year of 2023-24, the Auditor General of South Africa identified that some of our matters under contingent assets were dormant. Hence, then we had to remove them. When we removed those matters, then we were left with a nil balance. Currently, as at the second quarter, we have a contingent liability amount of about 32 million, and our contingent asset as the department is 0. We have just over 1 million rand as a contingent asset, which is recognized in the books of SEE. Yes, why is it in terms of our contingent liabilities, I wish to indicate that these are the matters that have resulted in contingent liabilities. These are public matters, and we have disclosed them as such, in the sense that when one approaches a court, the matter becomes a public matter. The first matter is Lincoln Mara at 11.8 million. The second matter is Marcia Chivase at 10 million. We have Mahane matter at 33,000. And Dikele Dimukwena matter at 4 million. Sutherland, we have it's at 372,000, and Coastal Diesel is at 2.6 million. That then brings us to the total of 32 million rand. My apology, members. I think I have skipped slide number 4, which starts with the initial matters. My presentation seems to be running. I don't know what is happening. My apology on that one. Oh, yes, this is slide number 4, where we have your ABSA vehicle management solution matter. We have Royal Security matter, and then we have the Dolo, Mkalipi, and Ramahana matters. Together, then these matters and the ones that I've already covered, they make up the 32 million. In terms of contingent assets, as I had already indicated, we have one matter, FE Industrial Supply CC matter, sitting at just over 1 million rand, and that matter is recognized in the books of SEE. I've already indicated that during 2023-24, AGSA identified matters that were dormant, and those matters have been removed accordingly from our contingent asset register. In terms of the number of cases, I wish to indicate that during the 2023-24 financial year, we had 67 contingent liability cases, and the contingent assets were 11. The total number then was 78. During the 2024-25 financial year, we had 65 contingent liability cases and 29 contingent asset cases. The total number thereof was 94. I wish to indicate that as at the end of the second quarter, we have 84 contingent liability cases and we have 31 contingent asset cases. The total currently, we are at 115. In terms of in terms of financial, in terms of legal costs paid, I wish to indicate that during the 2023-24 financial year, we paid 33 million rand. And in the 2024-25 financial year, we paid 21 million rand. During this financial year, we have to date paid 6 million. That 6 million is comprised of Q2 figures being 2.9 million rand and Q1 rather, and Q2 being 3 million. If you add those two, you then come up with just over 6 million rand. My apology. In terms of types and trends, I wish to indicate that these matters are generally the same, with our oldest one in the narrative report being a matter that was instituted in 2021. So generally the matters are the same, emanating from your general civil and labor related matters. We have matters where there are issues around deregistration or registration of unions. Those are dealt with by the Registrar of Labor Unions. We have issues around extension of collective agreements. We have a few contempt of court application matters. We have unions that need to be placed under administration, and we have issues around non-compliance with various labor laws. Also, our cases involve review applications where we have employer-employee disputes. We also have cases around the constitutionality, legality, validity of laws. These cases center primarily around our employment equity. Members would have heard in the media about the application by the Democratic Alliance, the NIASA application, a Solidarity application, as well as the one by a business unit of South Africa. Those are the matters that center then around our recent legislation. We also have civil damages matters, as well as your motor collision matters, strictly where our vehicles were involved in accident with others. We also have a few matters where the department is cited as an interested party and there is no relief that is sought against it. That would be the end of my presentation, Honorable Chairperson. Thank you.
You are?
Good morning. Good morning, Chairperson. Good morning to members of the committee and to the DMs and the DG, the other commissioners available on the call, and all participants on the call. May I ask that the presentation is flighted?
How do I stop sharing?
You are muted also.
Thank you very much. Chair, may I ask to turn off my video now?
Please do and proceed.
Thank you. Thank you very much. As with the department, we were asked to present our litigation agenda for 24, 25, 25, for 23, 24, 24, 25, and 25, 26 financial years. So we've done exactly that, outlining our contingent assets and contingent liability for the time. In the next 3 slides, Chairperson, which I won't go through, what we basically do is just take the committee through the money mandate of the UIF, and then from there we deal with the issues that you have asked us to deal with, and then we reflect on some of the root causes of our litigation. Thank you. So on the 3 slides, just reminding members of the role of the UIF as it comes from the legislation, and the UIF having a mandate to provide social security to its contributors in line with Section 27(1)(c), which states that everybody has the right to social security. And then in the next slide, what we indicate is how we do that through registrations of workers with the UIF, and through collecting of the monies that are due from the workers by their employers, and then going into the issues of how we then safeguard the funds, and then also honor the claims when instances of unemployment do happen. So in the next slide, here we just outline that in the year 2023-24, we were dealing with 102 matters on our litigation register. Those 102 matters were made out of litigation that was against the fund of 98 cases, and litigation that is instituted by the fund of 4 cases. We also had litigation that we are able to quantify, because that litigation is just based on the amounts that persons are claiming against the UIF, and then litigation that is not necessarily based in the money, but based in how contracts are structured, which is the part that we're not able to quantify, because those are contract disputes of about 43, and then quantified contingent assets. I apologize for that spelling error there. Contingent asset being litigation that the fund has initiated of the 4 cases I spoke to, and there we are talking about 236 million worth of cases. And right at the end, we just indicate that the sum of our total quantified liabilities and assets get to 305 million. Thank you. So here we outline the type of litigation that we are involved in, from the quantified contingent liabilities, or litigation that has been instituted against the fund. These liabilities, as you can see, arises from the work of the fund, normal benefits, COVID benefits, TERS, job or ER issues, and then in some instances performance issues. And I think with all those cases, they add to around 55, with a total figure of 73 million that we are currently overseeing on the litigation register. What they talk to is the number of areas of our core business where we are called or we are taken to court due to clients feeling that they have been underserviced. The I think issue there in contextualizing that number, including the other numbers that we will show for 24, 25 and 25, 26, is that on average we will deal with around 15,000 beneficiaries that are paid, and they are paid between 8 to 10 million for the total sum of the beneficiaries. And of all those beneficiaries, this is the total number that we are now in court with to try and resolve the cases. Just a reflection that in the majority of the cases we process without having to deal with any litigation. Then I think at the bottom, we just indicate that when it comes to unquantified contingent liabilities, or where we're not quantifying the value because the dispute is really on our contractual and constitutional obligations, we're dealing there with around 43 cases, and those 43 cases are around our normal benefits, where people will feel that the way that we may have calculated the benefits is not how they understand the benefits to be, and we are now resolving that. And then on the PAYA, where we may not have responded to PAYA request to the satisfaction of those that have litigated against the fund, and then on COVID TERS, and of course where we have a labor dispute. So here the big matter is that these are contractual disputes that persons are wanting resolved through the courts. Next. And then on the quantified cases, we were just illustrating there where they are coming from. Thank you. Next slide. Next slide. On 2024-2025, we were dealing with 107 cases. It's important for members to note that because litigation processes are generally multi-year processes, the 102 that you saw in 23-24, a large chunk of it will then make the 107 that members will see there. We did see a drop in our own litigation that we instituted against others, with us having concluded those processes with the people we were litigating against. That's why you will see that there's a drop there in contingent assets, and in that financial year, our quantified contingent liabilities were 44, totaling 69 million, and unquantified contingent liabilities were 60, and then quantified contingent liabilities 3, amounting to 236 million as well. Next slide. And here what we do, again, just showing that those litigation cases are aligned to the normal business of the UIF in terms of our normal benefits, be it death, sickness type benefits, COVID, normal tests, contractual dispute, amounting to 44 cases, as I indicated, 69 million for 23-24. Oh, sorry, 24-25. Thank you. If we can move to the next slide. And again, just indicating where the origins of the cases are. Under normal UIF benefits, it will be individual claims where the benefit quantum were yet to be determined in as far as the cases where we can't quantify the values. And then on TERS as well, we've indicated PIA and then labor disputes. Next slide. Next slide. So the root causes, they are around our claims, labor relation disputes, PIA requests, COVID TERS, as I have indicated previously, and some of these cases running on a multi-year basis, which means in all the years that the committee would be looking at, there could be a majority of these cases running through all those years. Thank you. Next slide. So for 25-26, it was 106 matters, litigation against the fund being 104 matters that the fund was dealing with, and you will see a drop again with contingent asset, with us now pursuing finalization of these matters with our clients and stakeholders, and then quantified contingent liabilities at 61, amounting to 62 million, and unquantified contingent liabilities at 42 cases, and then quantified contingent assets, my apologies for that spelling again, at 222 million. So if we can go to the next slide. Again, you will see the trend remains the same in terms of the types of disputes that we are dealing with on our register. Please, the next slide. Here on the root causes, we indicate that it's around disputes relating to benefits, contractual obligations and expected performance, labor relations issues, PIA information requests. We indicate that legal service is currently identifying and separating active cases from dormant cases, a matter that we have to do on an annual basis in preparation of our financial statements, and that where files have been inactive for 3 years, we will then do a review within the fund on whether the matters are worth pursuing, and try and find a way to bring all those matters to a close. And what we are indicating here are legal costs for the 3 years that we were asked to report to the portfolio committee. You can see the reducing trend over time of our legal cost, reflective of the drive to try and resolve things out of court where it's possible that we do so, and that helps us to close matters speedily. As I've indicated, most of these court matters are multi-year, and they take a lot of resources out of the system to try and resolve. So we do prioritize resolving things out of court where it is feasible that we do so. You would see in 24-25 we had already halved the 23-24 legal fees bill, and then in 25-26, although we are still in the midst of the year, we're looking to also potentially halving the 24-25 legal bill. Thanks. The next slide. Thank you very much.
Thank you. I get to the compensation.
Good day, Chair, Honorable members, Acting DG and colleagues. My name is Madime Jalidwaba. I'll be presenting the report for the compensation fund, and I'll be looking at the following three key areas. The first area will be the issue of fraud, then I'll go to litigation, then I'll also talk about recoveries. And ma'am, can I go directly to slide number 3? If I can go directly to slide number 3, ma'am. The intention is to just give context and be specific to the areas that I spoke about. We are experiencing litigations on the areas of medical payments, benefit adjudication, and assessment disputes. Those are the key areas that led to litigation, are still continuing to lead to this litigation. The other area, which is fraud. Most of the fraudulent activities relates to intercepted payments, where we indicating that we have 22 of such. If we go to the next slide, where I need to talk directly to the issues of the 22 fraud cases. All these cases are being ensured that they are dealt with. At the moment, all the cases, in fact, are at the investigation stage, referred to SAPS and different law enforcement agencies. And I'm happy to also announce that so far, a total of 27 million has been recovered through bank reversals and a few interventions. We also, as the fund, obtained preservation orders on 9 cases, which were worth 22.9 million, of which we believe, should we continue, we might recover even more. On the next slide, Honorable Chair and members, we just want to indicate all those 22 fraud cases that were taken to. As we indicated before, that those 3, there are 3 that has been sent to the senior state prosecutor, and others are being with other law agencies. And there are also recoveries, as you can see, that recovery of 26 million. So this is just to clearly indicate status per each case. If you go to the next slide, as I indicated, I won't be going through the entire presentation. Here we're giving litigations per volume. Honorable members will know that 2022-23, we had 82 litigations at the cost of 14.1 million. 23-24, 91 at the cost of 29.5 million. Then you see 24-25, 231 litigations at the cost of 17.7 million. The next slide, ma'am. I spoke about recoveries. I need to, in fact, towards the conclusion, because I needed to just summarize by giving these pointers. I need to talk about the matter of COMSOL. In 2009, COMSOL, there was a judgment in favor of COMSOL, allowing COMSOL to tap into the accounts of the fund and get monies. So the fund continued to fight against the judgment, and indeed, at long last, the fund got a favor, that is the judgment in its favor, and we are currently recovering from COMSOL an amount of 51 million. That is one of the positive things that we also just wanted to indicate. We have a number of issues and challenges in terms of litigations and addressing fraud. which as the fund, we are addressing through relevant stakeholders. We have challenges in terms of the weaknesses that we identified through the use of state attorneys, where there's overcommitment from some of the junior councils and weak oppositions. But these are the issues that, honorable members, we are dealing with. Chair, if I'm allowed, and acting DG, I would love to leave the presentation here because we just wanted to capture those critical issues. Thank you very much.
Thank you very much, CF. Chairperson, these are the presentations from the DAO, UIF, and CF, as you have directed, and we also tried to stay within the time frame that you've allocated to us. And with that being said, Chairperson, I can hand over to yourself so that we can receive questions, and the colleagues, we can then respond accordingly, if that's in order, Chairperson. I can hand over to yourself. Thank you.
Thank you, ADG. Thank you to yourself and the team from the department, as well as the two entities. I will now open up for members who would want to participate on this. I see Honorable Nkopane, hand is up. I check if there are other members that want to participate. In the meantime, proceed, Honorable Nkopane. I see Honorable Mkwili. Number 2, Honorable Mbele, 3. Let's proceed in the meantime, Honorable Nkopane, to save time. Unmute and proceed.
Okay. Yes, thank you very much, Honorable Chair. Honorable Chairperson, let me appreciate the reports that are being presented. And I've noticed that there's a lot of improvement and the accuracy that is noted in the reports. Now, coming to legal services on litigations, Chair, it is clear from the presentation that over the past 3 financial years, the Department of Employment and Labor has experienced a steady increase in litigation cases, evident from the rising total number of cases from 78 in the 2023-24 financial year to 115 by the second quarter of 2025-26. This upward trend indicates a growing legal exposure, which could be attributed to the expanding scope of the department's activities and the complex nature of labor-related disputes. The majority of these cases are contingent liabilities, encompassing both contingent liabilities and assets, with totals reaching over 32 million in the last quarter. Such figures underscore the need for enhanced legal risk management and proactive dispute resolution strategies to mitigate potential financial liabilities effectively. There's a lot, Chair, that I observed, but let me go to the questions. I've got only 2 questions from this presentation. What specific strategies can the department implement to improve the compilation and review process of litigation reports, thereby enhancing accuracy and timeliness? together with the timelines as they may put their timeframes. Then the second one, Chair, is given the increasing trend in contingent liabilities, what risk mitigation measures are currently in place and how can they be strengthened to manage future legal exposures effectively? Can I go to the next one, Chair? The CF. Chair.
I'm talking to myself. Unmuted, but I'm muted. So sorry, Honorable Moban, I did hear you. You are done. And I wanted to recognize the Honorable Mukwili as number 2.
I was saying, Chair, I've got 2 questions from the legal services on litigation. Now, can I take the next one on the CF? Or we'll deal with the first one and come back to the CF?
No, maybe let's do it like the presentations would have been done. That we take on each, you just indicate on which one you are asking.
Yeah.
Because I thought that you are saying you are done on that one, you will come back later on the other. But maybe let's say if you are ready with your questions, honorable members, just indicate which areas, just cover it at once.
Oh, thank you, Chair. Yes, on the compensation fund, Chair, I'm observing that the compensation fund has demonstrated commendable effectiveness in recovering stolen funds, with over 27 million recouped through bank reversals and asset forfeiture unit interventions in the past 3 years. The use of preservation orders on 9 cases valued at over 20 million indicates an active pursuit of assets linked to fraud proceeds. However, the fact that the fraudulent accounts had already been emptied underscores a vulnerability in timely detection. To enhance recovery outcomes, the fund should invest in real-time monitoring systems and forensic capabilities that expedite the identification of fraudulent transactions, thereby increasing the likelihood of seizing assets before they are dissipated. Speaks to the modernization of the system. Now, my question, Chair, quickly. I also have 2, even on this one. What specific measures are being implemented to improve the timeliness and efficiency of litigation processes, particularly given the delays caused by external legal and law enforcement agencies? The second question would be, how does the fund plan to strengthen its internal capacity and forensic expertise to mitigate cyber-related fraud cases in the future? Then on the UIF, Chair, I observed that the UIF faces a diverse range of litigation cases, primarily centered around benefits claims, contractual disputes, labor relations issues, and COVID-19 related claims. The main cause stemmed from UIF benefits disputes, which accounts for a significant portion of active and dormant cases. As indicated by the high number of unresolved matters, that is over 43 cases, with an unquantified liability of more than 62 million in 2025-26. A key observation is that many of these disputes involve incomplete documentation, pending adjudication, and disputes over calculation methodologies which suggest process inefficiencies. To mitigate this, UIF should prioritize streamlining claims verification procedures and enhance stakeholder education to reduce documentation errors and improve case resolutions. I'm also thinking, Chair, of what we saw in the Free State, the readiness of the office to educate the claimants and ensure that all those people that are sitting on the benches have the necessary documentation when they go in those lines for their attendance. Now, I have only 2 questions, even on this one. What steps can UIF take to enhance the completeness and accuracy of documentation submitted by employers and claimants to reduce the incidence of disputes related to UIF benefits claims? The second question, Chair, how can the UIF improve its case management processes to identify and resolve dormant files more effectively, thereby minimizing unnecessary legal costs and exposure? Thank you very much, Chair. If I still get time, I'll come back later to the narrative report on litigation cases. Thank you very much, Honorable Chair.
Honorable Ngobane. As I said, Honorable Mukwele, I'm not sure if you are back.
I'm here, Chair.
Yes. Can then come in, Honorable Mukwele.
Thank you very much. I can continue, Chair.
Honorable Mukwele, I said you can proceed. You'll indicate in the same order to which the presentation you're speaking to. Thank you.
No, thank you very much, Chair, and thanks for the presentation once again. Chair, I don't know whether I'll be out of order or what. However, I remember when the presentation about litigations came to us in the last term, we requested that the progress in terms of each case must be indicated to us. The report is too summarized. Even when you want to engage on it, it becomes difficult because it's summarized in such a way that you can't even tell how long is a particular case being handled and how long is a particular case being closed? How much does it take for one case to be concluded? So it becomes difficult for us to engage. We only see numbers and we only see amounts next to numbers. So for me, Chair, I would like for both entities to at least give us a written response into each case and how far it is. And also we did indicate in our previous engagement to say you are talking about staff members, but we don't know who are these staff members. Which department are they from? How deep are they involved in a corrupt activities, so that we know who are we dealing with? But if a report comes and say 7 staff or 10 staff, for an example, this is the amount, Tebogo's case litigation against the department. I'm giving an example. Tebogo, the amount is 100 million, for an example. How do you break down that 100 million? And like that share, if we can get that response, I think it will make our work very easy in terms of engaging into this vote. Thank you very much, Chair.
Thank you, Honorable Mukwile. Honorable Mbele.
Okay, thank you very much, Chairperson. Let me greet everybody, protocol observed. I'm sorry I joined late. I went for my filling of my chips at the back. So today, I didn't sleep, so they were giving me a lot of, I had to go back again this morning. I'm so sorry. So most of the presentation, I couldn't grab them. Even this one, I was listening to it while I was still busy collecting my medication. The only thing that I have picked up is the issue of interest on among cases. Because what I want to find out, Chairperson, is that in terms of recovery money, because obviously, unless maybe we can be told that those monies that are being recovered is the full amount that has been stolen. Now, if not, even if those, but we would want to know, maybe it was presented, I'm not sure, like I have indicated my situation. I'm sorry if maybe I'm going to repeat on something that was already presented. But my interest was to know how much money have we spent in terms of those cases, in terms of those litigation cases, and then how much have we recovered? Because we want to check whether, in terms of the recovery, did we really recover 100%? When I say 100%, I'm including the money for the lawyers. Maybe the person that has stolen some money, they were responsible for the lawyers as well to pay that amount. So I need to check whether are we losing. I know whether we lose or we don't lose. At the end of the day, there must be people that are accountable for the public money. But at the same time, we should also look at whether our cases are effective. They sit on time, they are prepared on time, and then the bandits, we get them very quickly so that we don't end up paying and spending exorbitant amounts on the legal fees. And then the other thing, Chairperson, I would really prefer that we must also work on the strategy on how we can prevent this corruption, because these things are really eating the money that we really don't have to budget for the litigation. According to what that has been presented, we are spending a lot of money on the litigation because of the people that are greedy, who doesn't want to see the community being empowered, be it the job creation and whatsoever that we can say. So it is very important that at some stage we really need to come up with a very solid and very aggressive system that is going to prevent those things, because really it's eating the money. Yeah, I think, Chairperson, at this moment, I think I will stop there. If maybe there's anything that I think of, I hope you will allow me to come back. Thank you very, very much. Thanks a lot.
Thank you, Mpele. The last to contribute on this is Honorable Nanzale.
Thank you, Honorable Chair, Honorable Members, Honorable Deputy Ministers, and the department as led by the acting DG. Honorable Chair, let me rather go straight to the question. The reason is that the time is running out and one may miss the public facility that moves everyone too close to the house.
On the question, with your permission, then Chair, on the legal services on litigation cases of the department, with the motivation and the points that have been raised already by my colleague, Honorable Gopan, I want to raise the following two questions. How does the department plan to address the high volume of labor-related disputes, such as non-compliance with labor laws, to reduce litigation and improve internal compliance mechanisms? The second one would be, what steps are being taken to facilitate better data collection and reporting on litigation cases, ensuring that legal trends and liabilities are accurately monitored and managed? Then on compensation fund. On compensation fund, Honorable Chair, I've got two questions again. The first one, given that some fraudulent accounts have already been emptied by the time of the detection, as the report indicates that in certain instances, the interventions by the system has in fact been or happened post facto, with the money already having been taken or cleaned out. So notwithstanding the fact that fraud has been traced, but the actions are in fact after the fact, and as a result, the loss is not necessarily minimized, notwithstanding the fact that culprits have been identified. So the question relates to that given that some fraudulent accounts have already been emptied by the time of detection, what enhancements are being considered to enable more real-time monitoring and faster intervention in suspect transactions? The second one is as follows, Chair, which relates to the partnerships and also the cooperation between the department and the police, including the prosecuting authorities. What strategic partnership or formalized collaboration is the fund pursuing with law enforcement agencies like SAPS and the NPA to expedite investigations and improve the prosecution rate of fraud cases? Then on the UIF cases, I've got 3 more questions, Chair, on the UIF. The first one relates to the steps that have been taken relating to the COVID-19 test claims, which reads as follows: what strategies can be implemented to better quantify and mitigate the unquantified contingent liabilities associated with COVID-19 test claims and UIF benefit disputes? The second one, in what ways can stakeholder engagement and communication be strengthened to prevent procedural disputes and enhance understanding of rights and obligations under the UIF framework? And the last one, how can the UIF leverage digital transformation and automation to streamline benefit claims processing, reduce administrative errors, and also decrease the volume of pending and disputed cases? On the last one, that is the narrative report on litigation cases, I've got 2 questions, Chair, on that one. That our health and safety protocols at departmental facilities such as labor centers adequately enforced and regularly reviewed to prevent incidents that could lead to injury claims and associated liabilities? I think there are quite 2 good examples that we can refer to Honorable Chairperson, with regard to the facilities at the labor centers, wherein 2 labor centers, in fact, in one, because the other one is just not opened for different reason, but one in a particular province that is Northwest, where the labor center was in fact closed by inspectors because it was deemed to be unsafe for people, either the staff or the public, to in fact to utilize it. So the question is basically follow up on that, but also taking into account the report that has already been presented. Then the second one, what dedicated resources and institutional frameworks are established to effectively monitor, manage, and streamline litigation processes to improve success rates and reduce costs associated with extended legal battles? Some of the cases, Honorable Chairperson, you may note that they are a bit longer in terms of their duration, and they, in fact, are not necessarily static in terms of cost. So the question is basically about ensuring that cases are dealt with as expeditiously as possible, notwithstanding the need to ensure that there is a fair balance between that speed with which they are pursued and the positive outcomes in terms of ensuring that they are properly prosecuted and the culprits brought to book. So those are the 2 additional questions, Chair, and that's the end on my side. Thanks, Honorable Chair and Honorable Members.
Thank you, Honorable Nanzele. You were last on this one. I will now allow the department and the 2 entities to respond accordingly. ATG.
Thank you very much, honorable members, for the questions that have been raised, and the colleagues on the platform will respond specifically to the questions that have been raised to the department, UIF and DEL. But on my side, I want to agree with the observation that the committee has made regarding the increase in the number of cases by the department. And I take the point that Honorable Makweli indicated in terms of really breaking it down in terms of how long that it takes. I also need to indicate that indeed in the department's legal unit, there are capacity issues that we need to be dealing with. Notwithstanding that, we are now beginning to think out of the box and also looking at ways and means whereby we can get additional resources to augment the current inadequate capacity. We'll be engaging the office of the Solicitor General to get private legal counsel to assist us in processing these cases in an expeditious manner. So that is one area that one needs to look at. And also, I do take the point in terms of the remedial actions, in terms of what actions are going to be undertaken in terms of the recoveries. I just need to indicate that through the asset forfeiture unit as well, we have begun to work closely with them to make sure that we recover assets in terms of what is being owned and through the process of crime, and any areas that needs to be strengthened, especially around strengthening of controls and disciplinary actions. Those are the issues that we need to be strengthening on. But the respective colleagues in the funds and in the department, they will elaborate in that order. Without too much taking too much time, let me hand over to the colleague from the department and then followed by UIF and the CF. Thank you. I'll come back afterwards. Thank you. Mditwa?
Thank you, DG, and thank you, Honorable Chairperson. May I just deal with all the questions at once, Honorable Chairperson, if you agree, those that relate to the department. In respect of the first question by Honorable Nkopane, I wish to advise that the department maintains a constant liaison with the state attorney so that when it's time to update the legal reports, we then don't have to be chasing them. I think that would assist. Also, I am of the view that we should start as soon as possible with the review process and adhere to our standard operating procedures and directives issued in terms of when the reports are due. Generally, there are directives that are sent to the officials to say that update your matter and by a certain date, the report must be submitted to an identified individual. Also, I think we need to deal with the issue of improved capacity so that we can better manage the unit, specifically the deputy directors who start with the compilation of the report. That would then enable us to ensure that we are able to comply with the relevant timelines. In this regard, I wish to indicate that we have had two colleagues seconded to the legal unit. One is a deputy director, one is a director who is then assisting in ensuring that we are meeting the timelines and the report is reviewed timelessly. In terms of the second question, I wish to indicate that we have various policies that guide our work, which we must follow. Those policies were drafted by the Department of Justice and Constitutional Development. They were initiated by the Solicitor General. If I may quickly indicate, we have a policy on initiating, defending, and opposing matters on behalf of the state. We have a policy on briefing and outsourcing of state legal work. We have management of state litigation. So we rely on those policies. Over and above that, we have our own standard operating procedure, which we use. There is also a policy on mediation, which we comply with. We comply with that policy from the onset in terms of us trying to negotiate with the relevant party as early as possible so that the matter could be settled out of court. If that fails, then generally you have to invoke mediation processes before you initiate your formal processes. It so happens then sometimes that if we are sued, the attorneys would indicate that they are not agreeable to mediation as provided for by the rules. I think that is what we are doing. The question by Honorable Nkwele, I think it's more to the funds, as well as the question by Honorable Bell is more to the funds. It will be noted that in the litigation report for the department, we have indicated the date when the matter was received, the reference number, the description of the matter, the current status, where the matter is, the province, as well as age analysis, including the official that is handling the matter in the department and the relevant state attorney. In terms of recoveries, we have one matter, which I indicated that it is in the books of SEE. If then Honorable Bell requires details of amount spent there, I can certainly liaise with the finance unit of SEE to just determine how much money has been spent. Coming to the questions by Honorable Nontsele, question 3 and question 4. I am of the view that we need to increase the inspection and enforcement services within the department. I know that the department is in a drive of recruiting not only the 20,000 inspectors, but to also improve in the filling of various outstanding vacancies. I'm also of the view that we need also to have a two-pronged approach, which I call the carrot approach and the stick approach. The carrot approach would be where the department conducts advocacy sessions on various labor laws that it implements. I know that those happen, and our branch that deals with employment equity matters has actually had a number of those. On the question of the stick approach, normally the department gets written undertakings from employers who are not complying, whereafter then if there is still non-compliance, relevant fora are approached for appropriate action, including your compliance orders. The last question number 4, about data collection, I am of the view that we just need to improve our litigation management as espoused in the relevant policy, and we also need to keep records of each matter. I think we also need to make a follow-up at least twice a month with the relevant state attorney so that we know where the matter is. We may also then do advocacy sessions with the branches to ensure that everyone is on board. The officials in the legal services unit have in fact committed to conducting advocacy sessions in this financial year, among others around contract management. The last part that I would suggest is that as soon as we receive a contingent liability matter, we would then update our contingent asset and our contingent liability and contingent asset register so that we keep track of the movements. Members would have noticed then in the presentation that I did indicate the movement in terms of Q1 of the current financial year, as well as Q2 of the current financial year. Thank you. Thank you, Honorable Chairperson and Member.
Thank you. Thank you, honorable members and Chair, for the questions. One of the questions that was asked to the UIF is on how we are using training, educational outreaches to assist members of the public and clients of the UIF to be able to understand how to engage with the UIF in order to minimize litigation. We do that on different platforms. Right now, as far as completing applications is concerned, within the fund, colleagues are working with employers and organizations across all provinces to educate employers on the legal requirement for them to submit information to the UIF and submit it in complete and accurate form, because once we receive information in that way and employers comply with the information, it makes it easy for us when we retrieve those records at a point of claims to be able to do that much faster than when we don't have complete information. On the issues relating to our contract management and continuing to reduce our legal bills and litigation arising from contractual disputes, we're looking into developing a PMU that will deal with contract management. Contract management is both a function that is in procurement, with the CFO, but also sitting with various units within the UIF, and then of course the role of our legal services. We're trying to see how we can streamline all of those, have a PMU where contract management is their center of focus, so that some of these disputes that then come at a point of implementation are minimized. And then we were asked on claims, how we are improving efficiencies as far as claims are concerned. We're implementing a claims processing system that will have built within it business intelligence that will help all of us monitor claims. When I say all of us, I mean that it will assist for management to also have sight of where claims are in terms of when they are received, how quickly they are assessed, and that would just empower us to be able to have better oversight on the processes, such that we don't deal with matters at a point where there are complaints. On the TERS side, the COVID TERS, it's work that we have to continue to do, and members would recall that there was a point where clients or claimants were allowed to submit documents relating to COVID to the UIF. Now the process of validation of those includes that there must be a physical verification. This physical verification is very important because it just allows us to eliminate all those potential future litigation because people have claimed incorrectly against the UIF. There are certain areas where we are receiving pushback, employers not availing themselves for some of these, but in those instances we just do what we need to do, which is not our preference, but then we will withhold any payment until all relevant work has been done to validate that we are dealing with a valid claim. And members are correct that some of this litigation may arise from people not also understanding their rights and their own responsibilities in as far as the UIF is concerned. And for that reason, we continue the work with various media platforms to educate people about how to complete documentation related to ensuring that their workers are part of the UIF, and also that workers are empowered to know what they can expect from the UIF. We've worked with a number of organizations, and included in that is working with some of the organized labor partners and organized business. And then I think on the issue that was raised, which is a legitimate issue of also improving our efficiency in as far as payments are concerned, we are in a process of automating our systems. There are certain of the systems that are automated. There are those that are not yet automated, but the plan is that we are trying to automate all our systems and also integrate the different systems that we are working on to improve efficiency when working with the public. And we're hoping that as we are implementing all of these, the result would be that our litigation register will decrease over time, and we will then be allowed to focus on the work of actually processing these claims much more efficiently. Members would have seen that we also reduced our our debtors book, which is litigation that the UIF has instigated against other parties. And our aim going forward is that we're going to do that two-prong. First preference being to try and resolve the matters out of court, because as we had indicated, it's a very speedy and cost-effective process to do things that way. But where it is it's not possible, then we'll have to approach the courts. And in this financial year, you would have seen that we did try and bring down our contingent assets so that they move from the litigation environment and are closed, and we can continue with the partnership with various stakeholders based on agreed contractual terms. Thank you very much.
Thank you very much, Honorable Chair and Honorable Members, for the questions. It's Madam Jaldova again from the Compensation Fund. The questions are indeed guiding us and also going to assist us to improve conditions within the Compensation Fund. Regarding the questions from Honorable Nguban, I think, in fact, the acting DG already alluded to the first question of measures to improve timelines and efficiencies. I'll go directly to the next question raised, which is more about strengthening internal capacity and forensic expertise. We are going to have a two-pronged approach here, honorable members, short-term and long-term. At short-term, we'll appoint a panel of forensic investigators who have this expertise of crime, cybercrime, and they will be appointed for a fixed term of 3 years. On the long term, it will be important that the fund create positions of forensic investigators within its structure. We have got anti-corruption unit, which already will make sure that this team gets space. On the next question, we noted comments by Honorable Mkweli and Honorable Mbele. What we'll do, looking at the current slide 5 of the presentation, we will detail that area, and so that we are able to go in each individual case, and also detail again in terms of the recoveries, how much general was there. Though the information is there, it might not be very, very detailed, so we'll go into that space. Honorable Nontsela raised 2 issues. The first one was looking at the issues of enhancement. What we have done as the fund, we have implemented a biometric system authentication when transacting on the compensation fund claim system. That is, this will make sure that ineligible transactions are not done. And the rollout has been completed in this space. We hope this will really assist. And again, we implemented the account verification system. That assists a lot when coming to capturing banking details to ensure that you are capturing correct details. Then on the next question that talks about collaboration, the fund is currently in collaboration with other law enforcement agencies within the Fusion Center. What we will be doing now to strengthen this collaboration and this relationship, we are going to ensure that we come up with a memorandum of understanding with the Fusion Center itself, where members, we note and we're aware that they're already assisting, and indeed, compensation fund cases now are really, really taken at first hand. So we need this memorandum of understanding to just solidify to ensure that we can really be assisted. Thank you. Those are the questions I could respond to. Back to the DG.
Thank you very much, colleague from the department and from the funds. These are the responses that we're able to provide to the honorable members, and we do welcome those. And with that being said, Chairperson, I will hand over to yourself. Thank you.
Thank you, DG and the team on the responses to questions asked by honorable members. And the things really also put in writing, and like the department would have done, which also gives the status of this and for some progress which is referred to as that would have been done in the Q1 and Q2 of this financial year 25-26. And sure further information would be received as we did. Yes, I've lost for a minute. I do not know what the network problem is now. It just showed unstable and went off. But the point I was making was that we'll still have the opportunity to engage these when we deal with the quarterly reports. And I must say thank you for coming before the committee and honor the items that members would have been interested in. Of course, with this undertaking that will still get detail in particular to CF and the UIF. Honorable members, I think with that having been said, Honorable Nonsela has given an indication already that, of course, those members that need to be in the House are also making their way to the facilities made available by Parliament to transport them to the House for a physical sitting this afternoon, so meaning that they are connecting from there. Let me then thank you, ADG, and I'm sure you'll be able to pass that to the ministry, that we thank you for holding up and answer these more of technical questions, as the report is also quite technical and operational in nature. Would not hold you to sit in a meeting now, but allow you to leave if you want to leave. If you so decide to stay, you can, as the report to deal with will be more of the committee adopting its own report. Otherwise, thanks once more.
Thank you, Chairperson and honorable members. Much appreciated. Thank you.
Committee support. I take it that the last item, description of the oversight report of the committee state. Honorable members, that's the report. We'll just scroll through the report. You will indicate the page where you are making a commentary on. In that way, we'll slack a bit as we get to observations and the recommendations we want to take to the House in that regard. You can then scroll, commit support. I'll just get an indication if a member wants to say something on a particular page. Just on the delegation. On the delegation. Yes, I'm trying to check if the apology is noted properly. Of Honorable Mukwili was on a way there and an emergency happened and had to return back, but was part of our delegation and we recorded it as such. So in the final report, if you can look at that, but like I'm saying, we can then move in that way. Now on observations and recommendations, as members would have asked before, that we should also allocate some time frames and responsibility so that we're able to track implementation. Honorable members, there's the report presented for your consideration. Once adopted, then it becomes the committee report on that oversight to be sent to the House. Because there are no issues that have been raised, I take it that it captures in general terms what the committee would have observed and recommends therefore to be addressed. Can I then have a mover and seconder for us to adopt this as our report? The Honorable Ngopane. Unmute and proceed.
Thank you very much, Honorable Chair. This report looks like a true reflection of the proceedings of our oversight, and it is captured in a way that is very much commendable. I move for the adoption of this report. Thank you, Chair.
Thank you, Honorable Ngopane. May I get a seconder, honorable members, for us to adopt the report as a committee report? Honorable Nanzele, you are recognized. Can proceed.
Honorable Chair, I rise to second the motion by Honorable Ngopane for the adoption of the report. Thanks.
Yeah, one of the report by Honorable Nonsele. Yes, depended. May I just check, honorable members, if there's any objection in us adopting this as our committee report to be sent to the House? I don't see any objection, so the report is therefore agreed to by the committee as a committee report adopted. Committee support, I take this would have been the last item on the agenda for today.
Yes, Chair. Yes, Chair. That's the last item on the agenda. Thank you, Chair.
This being the last item on the agenda, honorable members, I must once again thank you for the cooperation that we're able to finish at least within time without cutting corners, but engaging reports that are before us as we usually do. Of course, we do know that we still have, as I said, the quarterly reports, quarter one and quarter two, as well as outstanding minutes for approval next week. Would indeed communicate as we usually do, whether that meeting gets to be physical or it is virtual. We look at that also comparing the program of Parliament, which is also a living one, in that it gets to be updated from time to time. Of course, would take care again that members, you are also in the programs in your different constituencies, as we are already in the 16 days of activism for no violence against women and children. And I'm sure in your different constituencies, you are making the necessary contribution in taking the parliament debate that occurred on this matter to now practical actions on the ground. With that, honorable members, thank you. The meeting is adjourned.
By chair.
No, the chair.
Yeah.